All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning. You may be seated. Good morning and welcome to the 4th Court. The panel this morning consists of Justice Beth Watkins to my right, Justice Lori Valenzuela to my left, and I am Irene Rios. The court will now call cause number 420-599 CV in the matter of the marriage of Carlos Y. Benavides Jr. and Leticia R. Benavides. I'll take announcements from counsel at this time.
Sean Reagan, Carlos Saparini, and Guadalupe Castillo on behalf of the appellate.
Your Honor, I'm Richard Orsinger, my co-counsel, Edward Maddox, to Judith, sitting in the third row of the audience. We're here representing the appellate Christina Benavides Alexander, who's seated directly behind me. Your Honor, we're ready.
Thank you. As you know, the court granted oral argument on 2 issues only. The first is whether this court has jurisdiction over the portion of this appeal relating to the dissolution of marital bonds as argued in appellee's motion to dismiss. And assuming this court has such jurisdiction, whether the partial summary judgment granting a divorce to C.Y. Benavides Jr. based on the fact that the spouses have lived apart without cohabitating for at least 3 years should be reversed. Appellant will first address the court and address both issues for a total of 20 minutes. Then appellee will address both issues for 20 minutes, and appellant will then have 10 minutes of rebuttal. So we are ready to begin. Yes. Oh, and I'm sorry, as far as, thank you, your masks, when you come up to the podium, you are free to take off your masks. Thank you.
May it please the court. As Justice Rios just said, the court has asked us to address 2 issues this morning. The first issue, whether this court has jurisdiction to review the divorce based on living apart without cohabitation that was rendered by the trial court on summary judgment. The answer to that question, as determined by every jurisdiction to address the issue, is yes. This court has jurisdiction to review whether the summary judgment based on living apart without cohabitation was proper because the divorce decree itself affects the significant property interests of the parties. The second issue the court has asked us to address is whether the summary judgment itself granting divorce is proper. The answer to that question is no, for many reasons. The most important reason for why the summary judgment is not proper is that neither Leticia nor Carlos consented or agreed to the living apart without cohabitation. This was a forced separation, a forced living apart, and a forced lack of cohabitation by a third party who has a financial self-interest in seeing that the parties were divorced. This is not the law in Texas, and it cannot stand. Now, to the first issue of jurisdiction. Again, every jurisdiction, including the Texas Supreme Court, that has addressed this issue, says that the death of a spouse on appeal does not moot the review of the underlying divorce decree if the divorce decree, the resolution of that appeal will affect significant property rights of the parties. That's the done case for the Texas Supreme Court. In our rejoinder, we cited the other state Supreme Courts throughout the country that have addressed this issue, including the Washington case in marriage, the Ray marriage of Himes, which noted that every jurisdiction, again, that has decided this issue has said, yes, the court has jurisdiction. And why? Why is this good policy? The reason why is once you have a trial, or in this case, a summary judgment, where the parties have actually litigated the divorce, to cut off the right to meaningful appellate review would deny the losing spouse, in this case, Mrs. Benavides, a right to meaningful review, the right to due process. They'll have that judgment reviewed. In the cases we cite, including the cases they cite, the N. Ray Wilburn case. For example, if there was a lack of service, one spouse the husband filed for divorce, didn't serve his wife, got essentially, not exactly a default judgment, but basically a default judgment. The wife could come back, of course, after the husband has died and set aside that divorce decree. That's what it says in Ray Wilborn at the Tyler Court of Appeals. That was the issue, the marriage of Himes in the Washington Supreme Court. And why did they do that? And Himes, because the wife didn't have any notice, wasn't served. The husband committed fraud in filing a false affidavit of service. She was able to come back, get the divorce decree set aside later, even though the husband had remarried prior to his death. And why? Because she was a dependent spouse entitled to Navy benefits, retirement benefits, a significant property interest. Without those Navy benefits, she would not be able to survive. Another reason why it's good policy, what if one spouse files for divorce while the other spouse is incapacitated and not represented by a guardian? What if there's extrinsic fraud in getting the divorce? There has to be some method of challenging that divorce decree, some method of having jurisdiction, especially when it affects significant property interests. And here we do have those significant property interests. Now, the other, Ms. Alexander has argued there's marital property agreement, there's no community property, everything was Carlos's separate property, so this isn't an issue. But there are significant property interests in this case. Even if every piece of property, every piece of land, every bank account, every piece of clothing was Carlos's separate property, there's still property interests in this case that would be resolved by whether the divorce decree is valid. The most important one is, as a surviving spouse, if Leticia sets aside a divorce decree and she is a surviving spouse under Texas law, she has a life estate in the homestead, even if it's Carlos's separate property. If Carlos died intestate, Leticia would be entitled to receive 1/3 of his separate property under the intestate statute. And do we have the will? We have bank accounts. We have life insurance policies. We have retirement benefits. Those are all significant property interests that extend beyond this case. And the other side has now said, well, the will, the paid on death bank accounts, the right of survivorship, those aren't really property interests because those are all contingent. Those are all hypothetical. That's not a vested interest. That's just an expectation of a property interest. But the hypothetical, the contingency no longer applies because Carlos has now passed away. The will can no longer be revoked. The will can no longer be amended. He can no longer change his right of survivorships. He can no longer change his paid on death accounts. He can no longer change his life insurance beneficiary. And he can no longer change the beneficiary of his retirement benefits. So whatever property interests that Leticia would have as a surviving spouse are now vested. And therefore, that's why this court has jurisdiction. Whether the divorce decree was properly granted affects significant property rights. And there must be some significant or some meaningful manner for Leticia to review a decree that was entered erroneously. Otherwise, she's denied due process. Now, to the second issue, whether the divorce based on limited part without cohabitation was proper. We say it's not for a few reasons. Again, the most important reason is that neither Carlos nor Leticia consented to the living apart, nor did they consent to the lack of cohabitation. We cited the Texas Supreme Court cases, Willman, going back to 1923, 100 years.
Counsel, is consent an element in 6.006 of the Texas Family Code?
I believe if you read chapter 6 as a whole, yes. And I say that because the underlying basis, the bedrock principle of our matrimonial law in Texas is agreement and consent. That's why we don't let minors get married. That's why agreement and consent is an essential element of a common law marriage. And if you look at the rest of the basis for setting aside a marriage, the annulment statutes in chapter 6, I believe it's 6.106 to 1.09, you can annul a marriage based on intoxication, impotency, fraud, duress, force, mental incapacity, provided you have not, and the statute says it's voluntarily not cohabitated with your spouse after you learn about the fraud, the intoxication's worn off, after the incapacity was discovered and all those things. So if you read Chapter 6 as a whole, there has, and you consider the fundamental basis of what family law is, there has to be some agreement. There has to be some consent.
Is 6.006 a fault ground or a no fault ground?
We would submit that it's a fault ground. And there may be some cases say it's a no fault ground, but in this case, it has to be a fault ground.
And I understand that argument because you're kind of tracking in some of the intent requirements that seem to be present in the fault grounds that are missing in the no fault grounds. But it seems to me that that's an important distinction. Let's talk a little bit about
Sure.
that.
In this case, where you have an interference by a third party, and they have their reasons for why they think it's justifiable interference. You have interference by a third party. A third party has come into the marital home, taking the husband out of the home, forced the separation, forced to live apart, and forced the lack of cohabitation without either party's consent or agreement. And this is a problem in this case specifically because what they've told us now in their briefing is we filed for divorce under section 6.006. There's no defense, they say. Once we establish that they lived apart without cohabitation, it's essentially strict liability. Once the 3-year statute hits, there's no defense. And in fact, they said the court must grant a summary judgment based on that evidence, even though the statute says may.
But if your argument is that we should graft some kind of a mental component into this, a voluntariness requirement, isn't that a question that's more appropriately posed to the legislature to amend the statute? Because I don't see any kind of voluntariness requirement in the plain language of 6.006.
For whatever reason, 6.006, you're right, does not say voluntarily cohabitate, unlike section 6.106, 107, 108, 109, and 112. And if you read the statute of the act as a whole, I think that's an inadvertent omission. There has to be some consent or some agreement. That's the whole basis of family law, two consenting adults, right? And here they say you don't have a defense. There's nothing you can do. Well, because I had this court order, I was allowed to do it. Well, that's really the rub here. One side of the divorce case, there's no defense. That's what they say. Because we had this court order, we were justified in removing him from the home. Okay, I want to go to the guardianship court and challenge that March 6, 2013 order. But we all know that every time we've gone to challenge that March 6, 2013 order, Leticia's been told she has no standing. So effectively, she was divorced on March 6, 2013. As soon as the next month, Alexander took Carlos out of the house. That was a March 6, 2013 order that Leticia was not a party to. She was not heard on. She was, in fact, not allowed to even participate or listen in on the trial. So on one hand, they say we have this court order allowing us to take him out of the house. A court order you can't challenge. A court order you weren't heard on. Court order you can't do anything about. But over here, we're going to say you can't use that against us. You have no defense. And that's just wrong. There has to be some method, some defense to what happened here, to the living apart without, especially when it's a forced separation by someone with a financial self-interest in the case. Alexander made the living apart. She made the lack of cohabitation impossible, made the cohabitation impossible. She took Carlos out of the house. She wouldn't let Leticia even visit her husband, even though there was a court order. She filed an affidavit to support the summary judgment. That was the only evidence in support of her summary judgment. It says, I immediately violated a court order for visitation. This was an intentional interference with the marital relationship. We don't allow that in this country. That's Lawrence v. Texas. That's, what's the other one? Loving versus Virginia, Oberfeld. The government doesn't get to intrude in our marital relationship, into our intimate relationship like this. We certainly shouldn't let a third party do so armed with a court order from a corrupt judge. There has to be some method to challenge this divorce ground. You can't just say it's strict liability after 3 years, by the way, which we caused. and you couldn't do anything about the cause. There
Mr.
has-
Reagan, obviously, the divorce decree incorporated what the court, the order on the summary judgment. Do you agree with me?
Correct.
So we've got to look at this from a summary judgment. Was there a genuine issue of material fact raised in Leticia Benavides's response to the summary judgment? Can you tell me, from looking at the evidence that was presented in the response, where was an issue of fact raised? I know that she testified about visitation, but visitation is different from cohabitation.
I
Do you
agree. with that.
agree? So can you point that
Sure.
out to me?
In our summary judgment response at 2799 to 2800, we talked about how the separation, i.e. the living apart, wasn't by choice, how Alexander intentionally interfered with Carlos and Leticia's marriage, and how Alexander removed Carlos from the home over Leticia's objections. That's 2799 to 2800. In her affidavit that was attached at 2803 and 2805, paragraphs 10 and 18, Leticia set forth that Alexander removed Carlos from the marital home over her objection, that Leticia never consented or agreed to Carlos being moved out of the marital home. At no time did Carlos ever tell Leticia or indicate to her that he wanted a divorce or cease living with her as husband and wife, and that Leticia always wanted to cohabitate with Carlos, and that Alexander prevented her from doing so. This was also raised at the summary judgment hearing and in our post-trial motions.
And one of the things I think in, for example, number 17 of her affidavit, page 3, she avers, my husband has always wanted me to be with him, and he did not want to be at the address where he was moved to. Now, one of the questions I've got is, there is no indication by looking at her affidavit when these statements were made to her. Was it before he had a guardian, before he was a ward? Was he competent when he made these statements? So can you talk about that?
Well, I think the simpler answer to the question, hopefully, is that once he was removed from the home in April 2013, he was declared to be incompetent. So anything that happens after that date,
You have 5 minutes.
he wouldn't be competent to make an affidavit or to make any statements. So we have Leticia's affidavit, which she asserts all the things we've talked about this morning, and also the fact that Carlos never told her that he wanted to get divorced or move out of the home. So it'd been impossible for Leticia to get a statement from Carlos after he was moved out of the house, after he was declared incompetent. It wouldn't be competent summary judgment evidence. So I think that's the easier answer. Now, the other grounds we talked about in our brief for setting aside the summary judgment based on living apart, we talked about our capacity objections. I don't know if that's within the scope of the court's order or not. But
You may go ahead.
Sure.
if you like.
it is a basis for setting aside the summary judgment, so I'll address it briefly. The first part is any order entered by Judge Garza is void. All we had to do was raise a genuine issue of material fact as to whether or not he had an interest in this underlying case. He stepped down from the bench for soliciting a loan or a bribe, not from some random third party, from one of the parties in this case. He was indicted. In exchange for the dismissal of that indictment, he agreed to give up his law license. So he gave up he was the longest tenured representative in Webb County at the time. He gave that up. He gave up his law license. He gave up his livelihood. And we have evidence that he overpaid Shirley Mathis, the person he solicited this loan or bribe for. She submitted an invoice for about $260,000. He, for whatever reason, without hearing, paid her $300,000. And we itemized the rest of our evidence in our response. But at the summary judgment stage, the court has to accept this evidence as true. And if there's any doubts about this evidence, it must be resolved in favor of Leticia. And all reasonable inferences about this evidence, circumstantial as it may be, must be resolved in Leticia's favor. We think that evidence alone, that his orders are void, every single order he signed is void. We believe we raised a genuine issue material fact on that issue. Now, the conflict of interest objections, they say they're removal objections. They should have asserted in the guardianship case, like the forced separation. This is a catch-22 procedural trap. If we had not raised these capacity objections below in response to the summary judgment, they would have came in here and say we waived it. But let's go back to the bigger picture here. They say these are removal objections we should have asserted in the guardianship court, but they were never, quote unquote, never heard. But that ignores the fact that we did file a motion to remove Alexander in the guardianship court, which they concede is virtually identical to the capacity objections we assert here. That motion to remove was dismissed for a lack of standing. And this court in late 2020 reversed that order. So the trial court here, and you looked at the order he signed, he refused to rule on the conflict of interest objections because he had previously ruled in August of 2019 that motion, on the motion to remove. So he refused to rule on objections about the conflicts of interest based on an order this court had already reversed. There's no discretion there. He can't refuse to rule on objections by relying on an order this court has reversed. But back to the bigger picture, you have to go over there to file your objections. But at the time, that case was on appeal. Are we supposed to serially file the same virtually identical objections over and over, have them denied serially, take serial appeals, more appeals to this court? We have been sanctioned. We have filed the same motion to guardianship court over and over again. So that argument doesn't hold water either.
I do have, before you wrap up, I do have one quick question about and it kind of relates to what you were just saying about the volume of appellate filings that this litigation has caused. What can you point to in this record to help me understand whether Leticia Benavides took an appeal after Alexander removed Carlos from the home? Was there a notice of appeal? Was there any appellate remedy sought for that at the time?
There was, I believe, a motion to vacate Judge Garza's orders at some point in 2014. There's some reference, I wasn't involved in it, but there's some reference that there was a waiver of the appeal. So the 318 appeals, I call it the interpleader appeal, that we decided last month or 6 weeks ago would go forward. But Leticia did challenge those orders again, I believe in 2019. And this court denied, affirmed based on the lack of standing. But that's the 801 appeal, or 831 appeal, and the 741 appeal, and denied mandamus, not on the merits, but denied a mandamus. So those challenges to Judge Garza's orders have been litigated, yes, in the trial court, and they've been brought to appeal here, but they've never been addressed on the merits by this court. And the last part about the order, they rely on Judge Martinez, quote unquote, ratifying Judge Garza's orders. Under this court, in re mass, this court has said a void order can never be ratified, can never be confirmed.
Your time is up,
Thank
Mr.
you.
Reagan. You'll have 10 minutes for rebuttal.
Thank you, Your Honor.
You're welcome.
Please, the court, Richard Orsinger appearing on behalf of the appellee. I have to say that I'm disappointed that the 20 minutes that I have for oral argument today, where I was going to focus on the two issues the court asked us to focus on, first jurisdiction and second procedure, has wandered off into the swamp of all the allegations of wrongdoing and what I would consider irrelevant considerations to the matters to be decided. And rather than go off track like that, I would ask the court to look at our brief where we've thoroughly responded to these allegations of wrongdoing, voidness. We've had multiple motions to recuse every judge associated with the case. Bottom line is, it's Christina's hope and desire that this is the end of a decade-long process in which Leticia has attempted to use every possible vehicle to acquire separate property wealth of her husband, even though she signed a premarital agreement renouncing all claims to that separate property. In this court, in a recent appeal, has decided or affirmed the enforceability in cause number 0419-00318CV. This court affirmed the enforceability of the premarital agreements and applied them with regard to a claim of oral gift of land. So what I'm going to do today, Judge, with my limited amount of time, is to focus on the two questions, which I see one as a jurisdictional question and one as a procedural question. The jurisdictional question is, does this court have the power to reverse the trial court's dissolution of marital bonds? And my co-counsel, Edward Maddox, encouraged me to emphasize with the court the difference between a moot case and a moot issue. And there's some confusion in the case law because of the failure to recognize that distinction. The Texas Supreme Court in Miga versus Jensen said, generally, when an event occurs after a judgment that renders an issue before an appellate court moot, the court cannot decide the appeal. In Kellogg, Brown, and Root, the Supreme Court of Texas, a case is not rendered moot simply because some of the issues become moot during the appellate process. And I found an apt description in the El Paso Court of Appeals. Olson versus Commissioner for Lawyer Discipline stated in another way, if a judgment cannot have a practical effect on an existing controversy, it is moot. And then there was a family law case, or I should say In re JJH, which was a juvenile appeal that cited a parent-child case that said Appellate Rule 7.1 that talks about continuing the appeal after death, of course, does not affect the issue of whether you have mootness of the case or mootness of the issues. Now, in looking at this issue about family law in particular, there's a special rule that's developed. And I found, to my great surprise, one of the earliest cases on point was from the United States Supreme Court. In one of its rare family law cases in Bell versus Bell in 1901, there was an appeal of a divorce, whether a party that was not domiciled in Pennsylvania could get a divorce. And by the way, Justice Rios, I see that you're writing my citations down. May I ask the leave of court to submit a list of my citations, because there are a number. Yeah, that way I won't be concerned about.
Thank you.
Yeah, thank you, Judge. So what happened was they were considering the divorce. The husband died, and this is what the U.S. Supreme Court said in 1901. The death of the husband, since this case was argued, of itself terminates the marriage relation. And if nothing more had been involved in the judgment below, would have abated the writ of error, because the whole subject of litigation would be at an end, and no power can dissolve a marriage which has already been dissolved by the act of God. But the judgment below, rendered after appearance and answer of the husband, is not only for divorce, but also for a large sum of alimony and costs. And I believe the court was talking about alimony and gross, which the common law states treated as a monetary award, which we in the community property state would say is a property division. And so they went ahead and ruled on the validity of the case. So we go to the Dunn versus Dunn case here, decided in Texas. And in Texas, I believe this is a mootness of the case issue. The Court of Appeals said the entire case was moot because the spouse had died on appeal. And the Supreme Court said, no, if the decree affects property rights of the parties, then the case is not moot, which means we have to ask two questions about our case. What are the merits of our appeal, and what are the property rights that were affected by the decree? A case that was not cited in either brief was Polvado versus Polvado out of the Austin Court of Appeals in 1978. And in that case, the divorce decree said there was a finding that there was no community estate. And then the husband died while he was on appeal, while the case was on appeal. And the Austin court said, we conclude that since the divorce decree did not affect property rights of the parties, the lawsuit involved only the marital status of the husband and wife. Upon the death of the husband, the trial court no longer had jurisdiction of the parties to the divorce action and the subject matter of the litigation. And that case was cited favorably by the Oklahoma Supreme Court. But what that means to me is the Austin Court of Appeals was saying the question then is whether the property rights, whether the decree affects substantial property rights, not does the decree affect the status that results from being married. I think all of the cases indicate that it doesn't affect the status for being married. So then if you look at the Tyson case out of Dallas in 2001, if the judgment affects the party's property rights as opposed to purely personal rights. So the Dallas court is distinguishing property rights from personal rights. And that becomes important when we consider things like the claim that a homestead is a property right, or that your status as a beneficiary under a POD account is a property right, or your status as a beneficiary under a will is a property right. We believe the case law indicates those are not property rights, those are personal rights. In the in re marriage of Cain decided by the Amarillo court in 2006, they plainly said, we hold that Jerry's death renders any issues attacking the dissolution of the marriage moot. So in that case, in re marriage of Cain by Amarillo, they were saying, we're going to say that the mootness is as to the dissolution of marital bonds, but not as to the property. And that's why it's important to understand the difference between the mootness of an entire case and the mootness of certain issues. The U.S. Supreme Court segregated the status of the divorce from the alimony and gross. And here we have the Amarillo Court doing the same thing, saying that the dissolution of marital bonds is moot, but the property division is not. Barty versus Barty, the appellate court, that was another death on appeal. The court refused to remand to dismiss and instead considered the court's claims on error relating to the property division. So once again, that court recognized that you can have mootness of the marital dissolution without having mootness of the property division. So given that Carlos died on appeal, then what remains adjudicable if it's not the status of the marriage? In Walsh versus Walsh, there was a death of the wife on appeal and it mooted the custody issues, but the court considered complaints about the property division, again, segregating mootness of the issue of property from death. Black versus Black said, it repeated basically Dunn saying that as long as the decree affects the property rights of the parties, then you don't have mootness of the entire case. But there are cases, and we believe the better argument is that there may not be mootness of the entire case, but there is mootness of the dissolution of marital bonds. So Nichols versus Nichols Tyler, 1995. This is appeal from a divorce, death during appeal. The court said an exception exists where the decree of divorce significantly affects the property rights of the parties. Again, that's a case mootness question, but built in that is a recognition that it's the property rights part that's not moot. They didn't say that the marital status could be reversed.
Let's talk, when we're talking about property rights, let's talk about the life estate that a surviving spouse has.
In a homestead? Okay, that was waived in a premarital agreement. So as a theoretical point, a court could consider that to be an issue, but we have a relinquishment of those kinds of claims in this particular case, which makes us unique.
Tell me what specific language you're relying on in the prenuptial agreement that would waive not only ownership, but also the life estate.
I don't have an answer to that question. I would ask the leading court to respond by letter if that's permissible. If it's an important issue to the court, would that be permissible?
Yes, you may.
Okay. So we have a number of cases on, for example, the McGinley case out of.
As far as that, would you please make sure to copy?
Oh, absolutely. Oh, yes, ma'am. No problem there. We believe that the property issues that were raised in this case are set out in appellant's brief in paragraphs K, L, and M. K is the trial court erred in granting summary judgment on the marital property agreements when this claim is barred by res judicata. L is the trial court also erred by granting summary judgment on the business and the property interests that were not resolved by the interpleader action, as those claims are barred by res judicata. And issue M was the trial court erred by declaring there was no community property. What is not subject to attack on appeal is the McGinley case out of the Galveston Court of Appeals in 56. You have no vested right in the marriage. That's completely according to the rules set up by the legislature. Survivor rights are not property rights, as Plummer versus Estate, which is in our brief. The right of survivorship does not create an ownership right in the funds during the lifetime of the party. Taking under a will, Archer versus Anderson, Supreme Court of Texas, 2018, a prospective beneficiary has no right to a future inheritance. So, Justice Watkins, to address your question about the waiver issue, let's assume for purposes of argument that we don't have an express waiver. And let's assume for argument that we don't have a general waiver, although maybe there is general language that would address that. Is that a property right? It's certainly not an ownership right. Homestead is a possessory right, but homestead is derivative. This homestead you're talking about is derivative of your status as a spouse. And so you have no ownership right. All of these cases talk about property rights, property rights, property rights. It's not moot if they're property rights, significantly affects property rights. So is the right of a spouse to a homestead in the event of the death of another spouse, does it survive a divorce? No, but does that mean that the appellate court can reverse the divorce because if they had not been divorced, there would be a homestead right upon death?
But if it's not a property right, I mean, then we're not saying from the law school analogy, it's not part of the bundle of sticks.
Okay.
What is it?
Well, it's a right that derives from a personal relationship of husband and wife. Just like if I'm a co-depositor with someone and I have a POD, I get, that's a relationship I have with that individual. When
But that's a contractual relationship that's established under the terms of the deposit agreement
and
with the bank,
the same
right?
thing for a will. A will's not a contractual right, but I am named in the will. So that if I get this divorce reversed, all of a sudden I go back to a will where I inherit everything that this man owns. So that again is not a property right. These cases keep talking about property rights. That's not a property right. That's just a benefit you would have from a personal relationship you would have, that if your spouse died, you get this benefit. So if you take this exception and say that the homestead exception allows us to go back and reverse the dissolution of marital bonds, then basically that exception swallows the rule. Basically, you're trying to restore a marriage that doesn't exist so that the spouse can have a homestead right that vanished when the divorce occurred. So as a practical matter, Judge, can this court reestablish the marriage? It takes two people who are living to be married. If this court reverses and sends the case back because of a non-property right, and every single case cited has to do with property rights, then we're reinstating a marriage between a living person and a dead person, and that's not what's contemplated. I mean, the U.S. Supreme Court said it was a decision of God. We say it's a decision of the Texas legislature. You can't reinstate a marriage between a living person and a dead person. And so this homestead right, which isn't a property right anyway, should not be the vehicle for this court to say we're going to undo the dissolution, establish a marriage that can't exist. So,
But it doesn't exist, not because of any actions that either of the two parties to the marriage took. The marriage doesn't exist because of actions that your client took.
well, it was a decision of the trial court. It's really my client's actions didn't do anything. First of all, everything she did was pursuant to court order and was authorized, and she had the authority generally as well as specifically. But secondly, my client's decisions didn't cause this divorce.
Other than the general grant of authority to the guardian, was there any specific court order that allowed her to remove Carlos from the marital home?
Your Honor, I'll have to say, because I wasn't involved in that phase of the case, I'm not sure.
It's a
Mr.
substantial
Maddox could
record,
tell
lots
you-
of litigation.
Mr. Maddox could tell you from this stand because he was there all the way along the way. I only got involved in about the last 4 or 5 years. So, but at any rate, Your Honor, I have only 6 minutes left, and I'd like to move on to the procedural question.
I've got a quick question for you.
yes, ma'am.
Mr. Orsinger. Okay, so you've mentioned the life estate, and you know, Justice Watkins asked you, we're in the premarital agreement. Could we look to say that that was disposed of in the premarital agreement, and therefore there's no property right or that Leticia Benavides would be entitled to? So again, we're dealing with summary judgments. So for us to, I guess, uphold or affirm a summary judgment, we need to make sure that the court correctly ruled and granted judgment as a matter of law, that there was no genuine issue of material fact. So with that standard of review that we have to follow, how can you tell us that as a matter of law, the summary judgment evidence disposed of the life estate, that wasn't left to be, and I'm sorry if I'm taking up your time here, but do you understand what I'm?
Yes, I do
saying here?
see, Judge. So de novo review on appeal, so it's irrelevant what Judge Martinez thought. Secondly, in Casso versus Brand, the Texas Supreme Court said that once a movement makes a matter of law presentation of evidence, the burden shifts to the other party to come forward with contradictory evidence. The only evidence we needed to provide was that the parties had lived apart for 3 years without cohabiting. We have proof of that in our unsworn declaration of my client, and there was no controverting evidence. And so in MD Anderson Hospital and Tumor Institute versus Wilrick, the Supreme Court ruled non-movement has no burden to respond to a summary judgment motion unless the movement conclusively establishes its cause of action or defense. We did conclusively establish. They came forward with no evidence. So that raises the issue of whether we had to do more than show living apart. The Family Code says the court may grant a divorce upon the living apart, but the cases that have interpreted that statute, which goes all the way back to 1913, was when it first became effective. They all indicate it's a no-fault ground, it's irrelevant why it happened, and that the cases say, even though the family code says the court may grant a divorce, it really means must. In Tejas versus Tejas, the Waco Court of Appeals said that a jury found that they hadn't lived apart for the required 3 years, I'm sorry. And the appellate court overruled that and sent the case back to the trial court to grant the divorce, indicating that the divorce was necessary regardless of the jury verdict. In Coleman versus Coleman, the Austin Court of Appeals said where evidence showed living apart without cohabitation for 7 years, then that was not error to grant the divorce. Our position is, Judge, that it's mandatory. And this no-fault ground is similar to the insupportability ground. And there are 3 cases, Cusack versus Cusack out of Corpus, Baxla versus Baxla out of Dallas, and Phillips versus Phillips out of Beaumont, that say that in an insupportability, the court may grant a divorce. In the event of insupportability, that's mandatory. The court has no discretion. So it's our position, Your Honor, that once we prove the living apart by summary judgment, the court was required, it was not discretionary, but the court was required to grant a divorce. We requested in our motion for summary judgment, not just a finding on living apart, but also that the court grant a divorce based on the living apart. And as a matter of fact, we even have in Grossman versus Grossman out of Corpus Christi, a premarital agreement was upheld by summary judgment. And the summary judgment showed there was no reasonable dispute, no characterization issues, and they granted the divorce by summary judgment. It was not error to grant the divorce by summary judgment. So it is okay if you meet the standards for summary judgment to get a divorce by summary judgment. It is not necessary to have a trial. Furthermore, we would argue the court is obliged. There is no discretion. If you look at the case law, which I'll submit on list, Judge, here was a case, Taylor versus Taylor out of the Waco Court of Appeals, granting a summary judgment for divorce based on the conviction for felony, which is a ground for divorce. So if you meet the criteria for a summary judgment, you can get a summary judgment by divorce. And I'd like to mention in parting, Your Honors, guardianship case out of this court in the matter of the marriage of Thrash, where a ward married without the knowledge of the guardian, and the guardian found out about that and filed a motion to have it annulled. That was decided by this court in 2020, and it was annulled without a fact hearing, and the spouse took it on appeal saying, I should have been given a fact hearing. And this court said the family code doesn't require a fact hearing. It just requires that the evidence be there to support the decision to grant the annulment. And in this case, the trial judge was the guardianship judge as well as he had knowledge of the guardian. He took judicial notice of the pleadings in the guardianship case and in the annulment case. And this court affirmed, saying there was no requirement of a hearing and that the evidence supported the decision to grant the annulment. In our case, our judge, Judge Martinez, took judicial notice of the guardianship file. So we have not only the summary judgment evidence, we have all kinds of evidence. And so if this court is going to look at it, we'll see we proved as a matter of law, living apart without cohabitation. There was no controverting evidence presented by Leticia. And we also have the judicial notice of the entire file, but we don't think it's even necessary because the summary judgment is valid. But if you decided the summary judgment was not valid, look at the entire record and see if the evidence supported what the trial judge did. If you feel like the evidence, even if you felt like it was discretionary, if you feel like the evidence supports the granting of a divorce, then there's no reversible error in granting it. So I'm out of time, Your Honors. Thank you very much. I'll submit the list of the cases so that we all are able to be reading from the same page. Thank you, Your Honor.
Thank you.
May it please the court. Mr. Orsinger referenced a series of cases, some new cases, but none of the cases he talked about dispute what I said at the very beginning, that every jurisdiction to address this issue has said this court has jurisdiction. The first case he talked about was Bell versus Bell, 181 U.S. 175, 1901 U.S. Supreme Court. And it's a 2-page opinion. This is what part he quoted. The death of the husband since this case was argued, of itself terminates the marriage relation. And if nothing more had been involved in the judgment below, we would have abated the writ of error, because the whole subject of the litigation would be at an end. And no power can dissolve a marriage which has already been dissolved by act of God. And it talks about the alimony, property interests, while the trial court had jurisdiction, while the appellate court, the U.S. Supreme Court, had jurisdiction to consider the appeal. Barty, another case he cited. In that case, when the Eastland Court of Appeal says, when a party to a divorce dies during the pendency of the appeal, the merits of the appeal, the merits can be adjudicated if the divorce decree affects the property rights of the parties. And in this case, the divorce decree affects the property rights of the parties, and Billy's death, therefore, does not deprive us of jurisdiction. So the cases he cites to you support our position. And as I said, every jurisdiction in the country is found that the trial court has jurisdiction, the appellate court has jurisdiction. Then he talks about mootness. And I want to direct the court to Angeli case from the Delaware Supreme Court, 560 Atlantic 2nd, 1028. Quote, the property interests continue to be at issue despite the mootness of the marital relationship, and therefore the appellate court is required to review the divorce decree itself to determine if error was committed, which would have consequences on the affected property interests. The mootness doctrine doesn't apply if property interests are at stake.
Mr. Reagan, can you direct my attention to where in the summary judgment response you raised the argument about the surviving spouse having a life estate in the marital home?
We did not raise that in the response.
But that's our summary judgment standard.
Correct. I believe I raised it in response to their brief saying they filed a motion to, number one, I couldn't have raised that in the summary judgment response because Mr. Benavides was still alive at the time. So
That's fair. We got a lot of moving pieces here.
I only raised that in response to their motion to dismiss for lack of jurisdiction and their briefing on that issue. So I think that's my answer. It would have been impossible for me to have foreseen that.
That wouldn't have been a ripe argument yet. I understand your point.
And if you go back to the Supreme Courts of this country that decided this issue about jurisdiction, Dunn, the Texas Supreme Court, Hyams in Washington, LaRocca in Louisiana, Angeli in Delaware, Lindley in Alabama, Owen in Arkansas, all cited in our rejoinder brief, and we can give the court also citations. The court has jurisdiction to hear this issue because property rights, property interests are at issue. We have the homestead issue, and we have the post-marital, the marital property agreements, provided that even separate property could be conveyed by these parties pursuant to a will. They talked about the prospective beneficiary, the expectation interests that we talked about in our opening. But those property rights, those interests are no longer, again, they're not contingent or hypothetical. Carlos has passed away. Those interests, if she's a surviving spouse, have vested. So we got to go back to see whether this decree was properly rendered. And for the reasons we set forth in our brief and our opening, we say there's not. And finally, if there are no more questions, I always want to, when I argue, I want to take a broader view and a longer view, because I understand that this case will affect not just the parties in this room, it'll affect other litigants around the state who read this case. And I'm assuming it's will be an interesting case to write. If we look at the broader view, the longer view, what happened here is pretty remarkable. Again, neither one of these spouses consented to the living part. This was a forced separation, a forced lack of cohabitation. They were forced not to live together. Well, why? But how? By how? Because the daughter, the adult daughter of one of the spouses, armed with a court order from a corrupt judge, removed him from the home. And she admits in her briefing over and over again in the summary judgment here, Mr. Orsinger came out right and said it. We're moving for divorce, so she takes nothing of the will. So all this stuff goes away. She did this to further her own financial self-interest. That this was allowed to happen is unconscionable. This cannot happen. Folks, third parties cannot come into our marital home and rip our spouse from us. And they can't do it with an order from a corrupt judge. And they certainly can't do it for millions of reasons that further their self-interest.
But Mr. Reagan, your argument presumes that Carlos would not have made this choice himself. And we understand that legally he did not have the capacity to make this choice or not. Back to the plain language of 6.006, there is not a voluntariness requirement in it. But what I hear you saying is that we should graft. I mean, certainly there's not, it doesn't require both parties to choose to live apart, right? 6.006 can
Correct.
operate if one party chooses to leave the marital home and the other wishes they would have stayed.
Correct.
But you're asking us to essentially graft in not only just a requirement that at least one party consent or consent to the removal when the legislature hasn't seen fit to do that. And I understand that these are circumstances that only a tortured law professor would sit down and write. But it seems to me that your argument is based on two assumptions, perhaps, that Carlos would not have chosen this himself during that period of time. And that's something we will simply never know. And also that the legislature meant, but failed to include a requirement that at least one party consent in 6.006. Help me with that.
Sure. Again, and I'm sorry if I'm struggling with this.
It's authority issue.
Everything in the family code, especially with regard to marriage, in all the cases we've talked about, all the Supreme Court cases about marriage, it comes down to consent and agreement. We choose who we court or who we choose to date, who we choose to agree to marry, who we do marry, and we can choose to end that marriage. That's when the family code provides that. That's why children cannot effectively give consent. And that's why incapacitated people can have a marriage annulled, provided certain things are met. So the whole family code's about agreement and consent. Two consenting adults, right? Everything in the family code's about that. Unfortunately, section 6.006 doesn't have the voluntary cohabitation language that's in 6.106, 107, 108, 109, and so on. But if you look at the act as a whole, there has to be some agreement consent. If I could waive my right to annul a marriage because I was intoxicated or incapacitated, because I chose to voluntarily cohabitate with my spouse after I was relieved for the disability, that's about consent and agreement. Same thing about the children. Informal marriage, common law marriage, essential elements. The parties have to agree to be married and consent to be married and hold themselves out. Everything in the family code is about, with regard to marriage, is about consent and agreement. So some stray voluntarily language left off of section 6.006, there has to be some intent there. There has to be some agreement and consent because it's everywhere else in the family code. And that's the best response I have for you, Justice. If there are no further questions, we ask that the courts reverse the summary judgment, either dismiss for lack of jurisdiction or remand with instructions that the trial court dismiss for lack of jurisdiction after the summary judgment's been set aside. Thank you.
Thank you. Thank you, everyone, for very good oral arguments this morning. Your case has been submitted, and Mr. Orsinger will wait for your letter with these case citations, and you will be notified when the court has an opinion. So thank you very much. We're adjourned.
All rise.